Thursday morning, everybody. If you're in the US today, at least, thank you for joining us. We will get started in just about 30 seconds. All right. Well, welcome, IFA friends. My name is Mike Lehman from IFA Government Relations. Thank you for joining us today. We're pleased to bring you this special IFA webinar, Making Sense of the FTC. And on January 12th, the latest in a series of Federal Trade Commission actions on franchising was published. And as you may feel about everything that comes out of the FTC, these documents appeared to be esoteric, sub-regulatory legalese. And so as a franchisor or franchisee, you may be wondering, what do these FTC actions mean to me? And how do I make sense of them? Well, this program is designed to answer these questions and more. So we are pleased that you joined us today. A few announcements before we introduce our three special guest speakers. First, today's webinar is being recorded, as you may have noticed. This recording and slide deck will be available on IFA's community site later today at community.franchise.org. That's community.franchise.org. And second, we will take your questions from the audience at the end of this program. You can enter your questions at any time during the program through the question function on your Zoom screen, and we will pose as many of those at the end as we can to our experts. But we've got a great discussion planned for you regardless. So now it's my pleasure to introduce you to our three expert guest speakers today. First, we have Mark Dady. Mark is the managing partner of Dady and Gardner, and he represents franchisees, dealers, and distributors in all stages of the relationships with franchisors and suppliers. And Mark is based in the Twin Cities in Minnesota. So welcome, Mark. And Dave Cook is partner with the Plave Cook law firm. His practice focuses on franchising, licensing, and supply chain transactions. And Dave has a particularly unique perspective on this subject matter, as he is also a former FTC attorney, and Dave is based in Falls Church, Virginia, outside of the Washington, D.C. area. And finally, my good colleague, Sarah Davies, General Counsel here at the IFA, also headlining today's program. Sarah has years of experience advising clients and representing franchise brands. And I will yield to Sarah first in a minute before opening it up with Mark and Dave. One quick disclaimer, as you see at the bottom of your screen, the views and opinions expressed in this program are those of the speakers and do not necessarily reflect the views or positions of the entities they represent. But we're going to have a great discussion, and we know you're going to gain from it. Before yielding to Sarah, we can move to the next slide, because I want to introduce, first of all, the responsible franchising platform that IFA has recently introduced that really is very germane to this discussion. You know, as we know, so much about the great American business model of franchising is going extremely well. We've never seen more than 800,000 franchise units in America as we do this year for the first time. And franchisees continue to invest in new franchises and grow their existing businesses. So, so much is very strong about franchising. But at the same time, franchising has never seen more scrutiny from regulators. So with that in mind, after a year-long collaboration with two different working groups of IFA board members and other franchising leaders, both of these working groups were led by Sarah Davies. In May, earlier this year, IFA released its responsible franchising principles, and you can see a QR code there on the screen that you can use your phone to go straight to IFA's responsible franchising page and all the information about what we're proposing. The bottom line is IFA believes the vast majority of franchise businesses have been franchising responsibly for years. And that's good because IFA believes it is the responsibility of all franchisors, franchisees, and suppliers alike to engage in responsible franchising, which we think should be practiced intentionally and consistently by all parties in the symbiotic relationship of franchising to protect this model. So we do have some policy recommendations to promote additional disclosure by both franchise brands and franchise sellers, as well as new encouragements for franchisees to do due diligence before making an investment. So that's high level of what we've been working on in the responsible franchising realm as it relates to some of the scrutiny from regulators like at the Federal Trade Commission. So with that, as we move to the next slide, it's my pleasure to yield to IFA General Counsel Sarah Davies to tell you a little more about both responsible franchising as well as to set the table about what's been going on at the FTC in recent months. So Sarah.
Hi, good morning. So as Mike said, these are principles that working groups have been working on for the last roughly 2 years. The idea of responsible, ethical franchising is certainly not new for IFA. It is memorialized in our statement of guiding principles that date back to 2013 and other policies of IFA going back much further. But the responsible franchising practices that we have focused on most recently relate to increased transparency and visibility, both during the franchise sales process and also during the franchise relationship, to strengthen franchise relationships. And so as it relates to the disclosure process during the franchise sales process of the relationship, which IFA views as the foundation of the relationship. It's where the relationship starts. So we have calls to action for franchisees, franchisors, and suppliers to franchise systems. As it relates to franchisors specifically, it's a call to action for improved disclosures, and the franchise rule is under review, which we'll talk about in a little bit. But this just highlights the recommendations of the group, setting clear goals and expectations during the pre-sale process through improved disclosures, through an FDD that is more comprehensible, more readable for prospective franchisees, connecting prospective franchisees with the right opportunity, and casting visibility on the franchise sales process and all of the parties that play a role in the franchise sales process. And then aligning on some collective goals, driving unit economics, embracing collaboration among franchisors and franchisees through open communications, including FACs and independent franchisee associations. Margaret, you can go to the next slide. The purpose of today's webinar is the FTC actions that were issued on July 12th. The FTC issued a statement of policy regarding franchisors' use of certain contract provisions, including non-disparagement clauses, confidentiality provisions, and goodwill clauses. They also issued staff guidance on the unlawfulness of fees that are charged to franchisors that are not disclosed in the FTD. Additionally, there was an issues spotlight that was a summary of 12 trending issues that the FTC identified in its review of comments that were submitted in response to the request for information that the FTC published in March of last year. In addition to the FTC reopening that RFI for public comment, with comments that are now due in October. Margaret, you can go to the next slide. So just to catch us up as to where we are with FTC activity. So the franchise rule that governs pre-sale disclosures has been under review since 2019. There were roughly 40 comments that were submitted in response to the FTC's request for public comment on whether the franchise rule should continue and if there were any modifications that should be made to the franchise rule. Resounding support for continuation of the franchise rule in those comments. Additionally, the vast majority of the comments did call for some improvement to the franchise rule, including very basic improvements to just bring disclosures in line with the current technology environment, and reorganizing of the information that's presented. Following that comment period, there was a workshop on some discrete issues identified in the comments. And then the rule review has really just been stagnant since then. Just highlighting some communications to the FTC related to franchising from the Hill. 2022, there were bipartisan Senate and House letters to the FTC supporting the continuation of the franchise rule. 2022, we saw really the first in recent history of the FTC enforcing the franchise rule against a franchisor in the Burger IM enforcement action, and then followed by the request for information in 2023. Last year, June and November of last year, there were bipartisan letters from the Hill to the FTC regarding the FTC's lack of a focus on improving disclosures and focus on other aspects of franchising when there's an obvious and desperate need for us to improve disclosures in the immediate. Margaret, you can go to the next slide. So I wanted to have Dave just touch on a few shifts in the FTC in the last couple of years, just given his depth of experience at the FTC. And then we'll get into the conversation around the policy statements and staff guidance that were issued on the 12th.
Well, thanks, Sarah, and thanks to IFA for inviting me to this panel. I think the July 12th, the policy statement and other actions were, to me, very modest steps that are in line with the history, the franchising history that Sarah just recounted. But they also reflect the shift in policy focus at the commission over the last 3 years, and that shift. I mean, the current commission majority had a frustration with proceeding by individual enforcement actions, in part because the Supreme Court took away their ability to recover money in civil penalties in those enforcement actions. So there's been a great shift toward rulemaking, toward policy statements, and toward other outreach to the public to communicate the message, whether it's warning letters to companies that in areas that the commission has concerns about. So I think, again, the July 12th steps are very modest. We're not going to go through the other ones on this slide, but we may come back to them and touch on them later.
Margaret, you can go to the next slide. So just to highlight a lot of activity on the 12th, as we all saw. In addition to the staff guidance and the policy statement, there was a communication from the Commerce, Science, and Transportation Committee that has oversight over the FTC, really just highlighting the concerns with rulemaking generally from the FTC, a lot of which echoes what the IFA has put in its comments in response to the negative option rule that was proposed by the FTC, the unfair and deceptive trade practices or junk fees rule that was proposed by the FTC. And it's a concern with the FTC's focus on assumptions and anecdotal accounts rather than empirical data and evidence to support their policymaking. And a lack of concern or consideration for the impact of a lot of the rulemaking on small business in the form of increased cost in trying to understand compliance and implement the rules within their businesses to ensure that they are in compliance. So just highlighting that letter that was also sent on the same day. Margaret, you can go to the next slide. And then, the commission voted to issue the policy statement and the staff guidance on a 3-2 vote with Commissioners Ferguson and Commissioners Holyoke dissenting. Generally, and we'll get into it in a little bit more, in practice, collectively, everyone supports open communications between franchisees and regulators related to potential violations of law. The concerns that Commissioners Ferguson and Holyoke both highlighted were the policy statements attempting to or optically attempting to go beyond simply restating the law and suggesting that perhaps there are new obligations that would have triggered a rulemaking, but pushing through the attempts to change the law in these non-binding policy statements and staff guidance. So if you haven't read the dissenting opinions, I encourage you to do so. I think they're very instructive as it relates to this latest FTC action. So we're going to start the fireside chat portion of our conversation. Again, we're talking about the statement of policy regarding franchisor use of certain restrictive covenants. So non-disparagement clauses, goodwill clauses, and confidentiality clauses. The staff guidance on undisclosed fees charged to franchisees that weren't included in the FDD, and then the issue spotlight summarizing the 12 trending issues that the FTC identified in comment responses to the RFI. So with that, I will kick it over to Mike to lead us through the conversation.
Thanks so much for that, Sarah, for setting the table for us. All right, let's bring in our friends Dave and Mark fully into this conversation. Okay, Mark Dady, let's start with you first, in fact, and get into what the FTC has done here. So there's a policy statement, there's non-disclosure and goodwill clauses, and there's an issue statement, as well as the reopening of this franchise RFI that we saw over a year ago. So Mark, tell us your view, high level, of these documents and whether the sky is falling for franchising in your view.
Yeah, well, first, let me just say thanks to the IFA for inviting me here. I think it's important to have, franchisee viewpoints represented. And, while I can't speak for the entire scope of this, I do want to say thanks. Again, I'm not sure I necessarily agree with all the slides leading up to this, but it is good to be here, good to have an opportunity. I don't think the sky's falling, to be real clear. I think if you look at, I'll start by just talking about the confidentiality piece. I think that's consistent with existing law, right? I don't think that franchisors have the ability to prevent franchisees from talking to regulators. And candidly, I don't think that's what most franchisors are attempting to do. I think most of these provisions that you see are standard confidentiality, non-disclosure, non-disparagement provisions, but they're just, even if they don't specifically say they apply to the government, I think that some franchisees look at that and they're concerned that if they say something, they're going to be in trouble or they're going to have some fine. I see some of these, have liquidated damages penalties of a couple $100,000 for violating a confidentiality provision. And so I do think that they may have an effect of chilling some of that conversation. And so I think given that the FTC is trying to get info from franchisees, figure out kind of what's going on in the current state of franchising, I think this is just a helpful reminder to franchisees, hey, look, if you want to talk to us, we're here. And to franchisors, hey, look, just in case you were thinking about preventing somebody from talking, maybe that's not a great idea.
Thanks, Mark. That's great. Dave Cook, what's your view of how franchisors should react to these documents?
Well, I think they should not overreact at all. I mean, I think the policy statement is it's basically just a warning, and it's and it's not warning of anything new. As Mark said, and I agree with him, the notion that you cannot prevent franchisees or other parties from talking to regulators or reporting potential violations of the law, I mean, that's always been improper. So they're not saying anything new in this policy statement. And I think that the warning is just that, you know, when you ought, the franchisors ought to be conscious of the operation of these clauses that Mark mentioned. The confidentiality clauses or non-disparagement clauses. But it's really important to understand that a policy statement is not binding on the public, and it's not binding on the commission. It cannot be legally, it cannot be the basis for an enforcement action. So really, they're just telling you what they're thinking in this area. If they wanted to, find an instance of a clause that they find troublesome, they would still have to go through an investigative process and, either an adjudicatory or federal court proceeding or possibly a rulemaking, as if the policy statement didn't exist. I mean, because it really has no legal effect. It's just a communication with a warning that's included in it.
Okay, thanks, Dave. So policy statement, no massive course corrections necessary. Stay with you, Dave, maybe, and shift to the staff guidance.
Well, Mark, let me just say, I mean, I think if companies are wondering what they can do or should do in response to the policy statement, if anybody I mean, they should look at their contract language, and if it does expressly prohibit communications with regulators or reporting potential violations of the law, that's a problem. So you ought to address that. But if it does not expressly do that, there's really nothing that a franchisor has to do in response to the policy statement. I mean, you could, if you wanted, I mean, I suppose you could add language that sort of says, hey, in case you didn't know, this is not intended to prevent you from speaking to regulators or reporting. So that's a step you could take, but the policy statement does not require franchisors to do anything.
Yeah, okay, and
yeah,
and franchisors prohibiting communications with regulators was a problem even before July 12th, correct?
Oh yeah, I mean,
so nothing.
As Mark said, this has always been the law, and you're seeing similar communications come out of other federal agencies. So it's not unique to the FTC either.
I would say, Dave, to your point, maybe it's not required, but I do see in a very small number of these confidentiality provisions that, when they're talking about exceptions for example, responding to subpoenas or doing something like that, there are some exceptions that will say, and by the way, this isn't intended to prevent you from talking to the government. So even if not required, that may be something people.
Yeah, it's not. Yeah, it might be a good idea, but yeah, in case if there's any, just to eliminate any question about how your clause is intended to operate.
Good, thank you both. Maybe stay with you, Dave, and shift to the staff guidance regarding disclosure of fees charged by franchisors. Is there anything new here?
There is nothing new. It is, in fact, that's probably why it's just staff guidance and not a policy statement. Again, it's just basically a reminder that if you have a contract that with franchisees that doesn't include fees that you want to impose, then you have to consider whether it's necessary to amend your contract to add those fees. Or so it has always been the law that you cannot impose fees without your contractual authorization or without having disclosed them to consumers. The case that they point to in the guidance is this Orkin case. And what happened in that case was they had a customer guarantee with an annual renewal fee attached to it, and they had no provision for increasing that fee except for one particular situation. And in the mid 70s, when it was 10% inflation, Orkin said, well, we really got a problem because we can't increase these fees. So, I mean, they did attempt to increase them in something like 200,000 consumer contracts. So the FTC said, well, unilaterally breaching your contract is not a practice that is acceptable, and there's no way for consumers to avoid the consequences of that. So what the staff guidance here is just saying, you know, the same principle applies in other areas in franchising as well. So again, nothing new.
Thanks, Dave. Mark, your view of the staff guidance, anything to add?
I think it's helpful. I mean, I agree with Dave that this isn't new law. I mean, this is, you know, there's a good case that I like out of South Dakota, Bird Hotel, that related to a loyalty program, where the franchisor attempted to increase some fees and the court said that's a breach of contract. So I don't think that this is new, but I do think that when you're seeing a lot of things like tech fees coming about and some of these other fees, I think the FTC is sort of saying, look, we've heard some complaints and we're reminding folks that this is the law and this is our view of the law. I think that, you know, the opposite would be chaos, right? If a franchisor could, in my view anyway, if a franchisor could impose fees on franchisees that haven't been disclosed and don't have a basis in the contract, those aren't contracts, right? So I think that just reminding folks, if you want to charge franchisees a fee, you've got to disclose it in the FDD and you've got to have some basis in the franchise agreement, you know, makes good sense.
That's great, Mark. Sarah, I want to get you in here to get your thoughts overall on what these documents mean at the federal and state level and whether the impact you see.
Sure. I mean, I echo all of the statements made by Dave and Mark related to the policy statement. I mean, I think that that Mark is right. I think that it's an education gap. It doesn't require a regulatory fix. I think it's just educating franchisees that that franchisors and support open communications generally with regulators and that flow of information. You know, as it relates to the staff guidance, I think, you know, I think that specific example and the technology fees and everything that's going on just highlights, you know, an issue with the current disclosure regime. These are such long-term contracts. They're 10, 15, 20-year contracts. Franchisors can't predict what innovations and updates are going to be required to the system for the benefit of the system, for the benefit of franchisees, so that they can remain competitive with their non-franchise counterparts in the same industry. And so that change is so necessary. I think it's just a change management issue and how franchisors communicate those changes to their franchisees and demonstrate to franchisees, you know, why certain things are being implemented. So I think it's relationship management and change management. I don't know that I understand, you know, the staff guidance and policy statements are non-binding. I do think that they added a bit of confusion and ambiguity, as Commissioners Holyoke and Ferguson noted in their dissenting statements. And I think there's a need for clarity, but that's why we're working on improvements to disclosures with responsible franchising.
That's right. There is confusion, and that's why we're making sense of the FTC here on today's program. Thank you, Sarah. Mark, on that point about the fee disclosure, is this a good result for franchisees? What we're seeing here, editorialize a bit more for us, if you would.
Yeah, I mean, I don't know that I would say it's a good result because I think it's the only real result available, right? Because like I said, I think the alternative doesn't work. And I think that it does remind franchisors, look, if you want to make a change, and Sarah brought up a great point. I mean, this really is change management, right? How do you involve your franchisees? You know, one of the big things I think is important to a system is having a robust, independent franchisee association. And so I think that this is a reminder to franchisors, look, you may not be able to force a change down franchisees' throats if they don't want to, if it wasn't disclosed and it's not in the franchise agreement. But that doesn't mean you can't make changes, right? You just have to work with the franchisees to, you know, convince them that it makes sense to do it, right? Not because I can, but because it makes sense. And so I do think it's a good reminder because I think that kind of dialogue back and forth, you know, both helps franchisors make sure that they're making good decisions, right? They've got kind of a check on their decisions, but also involves the franchisees, which, you know, if you read some of the comments here, when the franchisees and their franchisee associations were involved, typically the franchisee base is less angry about change as it occurs, which, I think is a great statement for the benefit of independent franchisee associations.
Great. Thanks, Mark. Dave, to come back to you, how do you, we're talking about system change here. How do you see franchisors implementing innovation and these system changes?
Well, I think good ones, responsible ones, do it the way Mark just described. I mean, if you are looking to make a change, and there's not a strong basis for it in your existing documents, then I think you have to talk to you should talk to your franchisee community about it, because you're gonna need buy-in in order to implement the change if it requires an amendment of some kind. If you don't get buy-in, I mean, then I suppose you can offer a new program on a voluntary basis with a fee attached, and people can choose it or not choose it. But that doesn't promote consistency and uniformity for the brand. So I think if you really need to get buy-in and have it apply across the board, the best path is to make the business case for it to your franchisee community.
Great. Mark, anything you're seeing as far as franchisors here?
No, I do think that the optional programs that Dave talked about, I think those are interesting. I'm seeing that a little bit more, where franchisors will say, hey, look, we can't maybe force you to do this, but we think it's a good idea, and take a look at it. I do think that's both good, but as Dave said, there's a problem with, if 20% of your system adopts this voluntary program and the other 80 don't, there are problems with consistency. But I still prefer that over, forcing people to do things they don't have the right to do.
Very good. Okay, we've talked about the policy statement. We've talked about the staff guidance. Sarah, can we come to you to talk a little more about the issue spotlight, which was based on the comments received to the franchise RFI a year ago, and where is this headed, do you see?
Sure. So the RFI, the responses to the RFI exceeded 5,000. The FTC published roughly 2,000 of those 5,000. They deemed the remainder to be non-responsive, which they're able to do if they decide that certain responses are unresponsive or duplicative. And so based on the 2,000 that were published, there are these 12 issues that are identified, and certain of which relate to disclosure issues, relationship issues, increases in fees. We can't tell from the issue spotlight what percentage of the comments related to certain of those trending issues. So it's really difficult to understand how to prioritize those issues where the data shows that there was a prevalence of one issue over the other. But there's this list of trending issues. The FTC doesn't really go into a lot of detail in the issue spotlight about any of those trending issues, other than to cite a handful of comments that reference the issue with respect to each of the issues that were identified. And then all of that culminating with reopening the RFI, just generally not related to any specific focus or section of the 6 that were included in the issue spotlight. So it's reopened for comments through October. And so that's where we are with the RFI, which is not really anywhere.
Right. Thank you, Sarah. So just like IFA wanted responsible franchisors and Z's participating in the franchise RFI a year ago, and we helped galvanize a pretty broad-based response. We'll be doing that again in the really months ahead prior to the comment period closing on October 10th this fall. So long way to go there, but look out for more to come on the RFI. Mark, your thoughts on the RFI and the reopening and what franchisees can and should be doing here?
You know, I was kind of laughing and joking with somebody that said it sounds like the FTC's been tapping my partner's phones here because you know, look, these aren't issues that are in every system, but these are issues that every franchisee lawyer or franchisor lawyer deals with. Right? And like I said, not every franchisor has this, but you know, pre-sale misrepresentations, those are, you know, stuff that you see presented at the IFA. You know, a lot of people are talking about that, ongoing relationship issues. To me, the thing I was kind of maybe not most surprised about, but most interested in is that, you know, currently the franchise rule is all about disclosure, but this list of issues had a lot of, you know, kind of ongoing relationship issues. And so it'll be interesting to see kind of what the FTC does with that, if anything. You know, or are they just going to continue to limit their involvement to pre-sale disclosures?
Thanks. Dave, your thoughts, issue spotlight and new reopened RFI?
Yeah, well, first, you know, I would just say that to me, it's very troubling that of the comments submitted in response to the RFI, more than 50% of them were deemed to be non-responsive, without any explanation of why the commission considered them non-responsive, and not put on the public record so nobody else can look at them and sort of you know, express their own opinion about whether they're responsive or not. So it's an odd way to proceed, I have to say, and you know, I wonder, you know, there's going to be the next round of comments. You know, I'm not sure what to submit because I got at least a 50% chance it's going to be not counted because it's deemed non-responsive for some reason unknown. The issue spotlight to me is I'm not quite sure how to take it. I think it's probably, I kind of take it as a narrowing down of the original RFI requests. You know, it had a longer list of questions, and I think, you know, they're basically, you know, looking at of the comments they did review, the 2,200. These are the things that seem worth further comments. So I think they're really kind of trying to focus the next round of comments for the RFI on these 12 issues.
Yes. Thanks, Dave. We agree that it's troubling that many comments were not publicized and wonder what's behind that. We've shared that with some friends on Capitol Hill, and I agree that it's discouraging to participate. Again, if you're not confident the FTC is going to fully incorporate what you share, but probably still important for all of us to weigh in on the franchise community. So now let's pivot a little bit. Sarah, looking overall at this. Now actually, let's stick with the policy statement because that would be the target of any additional legal action. Do you anticipate a legal challenge to the policy statement or any of these documents?
I mean, I think it's certainly possible, right? I mean, I think that the FTC's, you know, the non-compete rule is currently being challenged, and it's, and I'll let Dave touch on it more, but the non-compete rule was unique for the FTC because it was the first rule in recent FTC history that was issued under its unfair competition authority. And so a different rulemaking process and requirements, but I think there's certainly a concern in the way the policy statement was issued. I think it's described very well in Commissioner Ferguson's dissenting statement about the concern with not the FTC staff encouraging communications, but the path in which they took to do so. So I would expect to see, you know, some sort of challenge to this latest activity from the FTC, particularly if there's a positive result in the challenge to the non-compete rule come the end of August.
Okay, thank you, Sarah. And as we talk about legal challenges, Dave, I'll come back to you, and Mark would love your thoughts as well. We just saw the recent Supreme Court decision in the Loper case dealing with Chevron deference to regulatory agencies. How does that Loper decision affect what the FTC has done here, you think?
Probably does not directly affect the policy statement, because those actually have never been entitled to Chevron deference. So that if the policy statement, a legal challenge to the policy statement would have to be effectively that it's not just a policy statement, it's actually an attempt to establish a binding rule. And I mean, there is a history of cases involving federal agencies and policy statements they've issued and the circumstances under which this can be challenged. It's a pretty murky area of the law, with different courts applying different standards. So it would be a difficult path, I think, as opposed to challenging the outcome of a rulemaking or an adjudication, which is entitled to review. So it's possible a court would not even accept a review of the policy statement. But like I said, the Chevron, the Loper decision, it comes in, I mean, it's very much more in play for the non-compete rule, which is already under challenge. And, we have one federal district court in Texas saying that, concluding the commission did not have authority to issue the rule. A different federal district court in Pennsylvania concluding that they did have authority to issue the rule. If that now there's conflicting decisions in different circuits, I think there's a pretty good chance it's going to work its way up to the Supreme Court. And when it gets there, the Loper decision comes into play, because it's a large component of the case is the commission's interpretation of its own authority to have issued this rule. So now you would assume that the Supreme Court would say that no deference should be given to the FTC on that conclusion, and the court should make an independent judgment.
Yep. We also saw the National Labor Relations Board recently pull back their appeal to the IFA challenge to the joint employer rule. So the IFA Law Center, led by Sarah, has fully defeated the 2023 NLRB joint employer rule. The NLRB withdrawing their appeal came out since the Loper decision as well. If that had any impact, that was certainly a big win for franchising as well. Mark, other thoughts on the Loper decision building off of Dave's comments?
Yeah, I'm just smiling because I've never worked for the FTC, so I would listen to Dave on this over me. But I will say that, I mean, I think that, look, both sides of this argument are looking for ways to influence outcomes here. And to the extent that rulemaking or the FTC's actions are, hampered or whatever, I think they'll look for other outcomes, right? Maybe there'll be legislative. I mean, so far there hasn't been much in the way of that at a federal level. But, if one avenue is shut down, maybe a different one will be explored.
Great. Then let's shift from the legal realm to the political. Dave, back to you, and then maybe close with Mark and Sarah. How will the election that's looming in November potentially change priorities at the FTC?
Well, if there's a change in the party in control, I think you could probably expect a shift like we saw 3 years ago with the incoming administration then. And it could be sort of a broader shift in policy back toward individual enforcement proceedings and away from rulemaking. I think that's quite likely. It could be, as the current commission did, it could be actual reversal of policy statements that have been issued in the last 3 years. So that could well take place as well.
Mark, Sarah, anything to build off there?
As it relates to the election.
Ladies first.
No, I was going to say, as to the election, no, I think that Dave's points are correct, as it relates to just, the flip-flopping of the agencies, just depending on the current political position of the administration and Congress. But I did, if we're making final points, I did want to I'm in New Zealand for a franchise conference, and New Zealand doesn't have, you know, a franchise regulatory regime. And it's so interesting to hear the conversations, because there's so much focus on what we talk about as responsible franchising, but there's so much focus around all of these principles and on communications between franchisors and franchisees, and focus on relationships and focus on healthy relationships. And the focus is there because it protects the model from regulation and from interference by government in this space in which they all play. And it seems to be working so beautifully. And so I think it's just a great example of what you can do with communication and kind of I don't want to say self-governance, but just, you know, managing within your relationship, you know, rather than having government come in and tell you what to do.
Great, Sarah. Yep. Of course, the commission does have, unlike a cabinet official, the FTC's leadership wouldn't be changed immediately in a new administration. Commissioners have rolling terms. But
a new chair would be appointed.
A new chair would be appointed right away. The majority may take a few months, but certainly, you know, 4-year time period, a new administration would have a chance to set their priorities at the commission, no question about it. Okay, if Mark, Dave, and Sarah have a few more minutes, we do have some questions from our audience, including a couple questions about the Loper decision, which I think we dispensed with. No significant impact of Loper and Chevron deference change on these documents. Next question, Mark and Dave, says, how do these FTC actions, I believe, impact settlement agreements that franchisors enter into with franchisees to resolve disputes? One of you wants to take that?
Yeah, I can answer that. I mean, to me, it applies equally to franchise agreements and settlement agreements. I think there's you know, the FTC in their comments had some broader things to say about talking with other franchisees, you know, prospective franchisees, et cetera. But this guidance doesn't touch on that. This is really, can I talk to the government? And so my read of this would be, even if you have a settlement agreement, you know, the government is telling you, the FTC is telling you that their view is that you're still able to talk to them and disclose your story about that.
Yeah, I don't really see it any differently. I think maybe the one limitation is that if in a settlement agreement where parties are actually releasing active claims, and if that's paired with a you know, commitment that as to what's been released, you're not going to instigate an investigation. I think that might be acceptable, but but in general, it doesn't really matter what kind of contract it appears in. I mean, the principle is that it should not be blocked from talking to regulators or reporting law violations.
Yeah, great. Next question, actually, we'll pose this one to Sarah. We've talked about fee disclosure a bit. The question says, can franchisors have language in their franchise agreement reserving the right to charge for something they currently do not charge for? And if so, how would they do that? Sarah, would love your thoughts, and then maybe Dave and Mark after that.
Sure. I mean, I think that's what's currently recommended, right? Is that if you think you may charge a fee, then you disclose that this is a fee that's not currently charged, but that may be charged in the future. I think that that's not necessarily a helpful approach or requirement for prospective franchisees, because I think what will happen is franchisors will include every fee that they may potentially charge at some point in the future because they don't want to lose the opportunity to be able to charge it. And I think it kind of muddies disclosures, but yes, certainly can disclose fees that are not currently charged, but that may be charged in the future. The rule currently requires also, if you're going to change the fees that are disclosed, that you provide, you know, a calculation for how those fees will be increased, or a cap up to which they'll be increased. And so there are certain parameters on fee disclosures already, that exist in the rule. So Dave, I don't know if you have anything to add.
No, no, not really. I mean, I do think what you're talking about in, you know, future increases in existing fees or potential new fees that you're thinking about but aren't charging yet. I mean, I think from the state examiner point of view, they would probably think of it the same way, that that's relevant information to know that might happen in the future, but you need to put a more concrete detail around it in terms of a formula or a maximum, so that franchisees know what to expect.
Yeah, agreed. I mean, you see that a lot in things like marketing fees, where maybe a brand new franchisor doesn't charge a national marketing fee, but they tell you they might do so in the future.
Great, good question from our audience, and thank you for the responses, all three of you. I think we have time for one more. Last question is, how do the new fee restrictions affect franchisor disclosing then current fees TBD? So I guess this is a similar take on the last question. Anything to add there, Dave?
No, no, I don't think they affect it at all, because as we discussed earlier, it's not new law, so it's really just proceeding in the same way.
Great. Our friend Bill Edwards notes that New Zealand has no franchise laws, Sarah. So while you're there and putting up with the very early hour, Bill wanted to throw that in. So
And very little litigation. So I think that was really the point, is that yeah, you know, but they do a great job of focusing on relationships.
yes, indeed. Thank you. Margaret, if we could throw the slides back up just as we close. We are grateful that Mark Dady, Dave Cook, and Sarah Davies would join us from their far-flung locations this morning and share their expertise. We have their emails, their email addresses in the chat box for any follow-up. Certainly encourage any of you to reach out to any of us for future conversation on this topic or other things. And then on the next slide, I'll show you that we are encouraging everyone to continue to promote responsible franchising. We think this is good for franchisees, franchisors, suppliers, and the like, the entire franchising community. Again, during this period where franchising is under the microscope, the website for responsible franchising is in the chat box as well. So we would encourage social media posts and to join folks like immediate past chair of IFA, David Humphrey, Planet Fitness franchisee, and Ron Feldman of Apple Pie Capital, and Dan Monahan, and other franchising luminaries who have promoted responsible franchising on LinkedIn and other channels. Would love for you to do the same, especially in context of this new RFI that we'll all have a chance to respond to prior to October 10th. I think we have one more slide. I want to lastly highlight that we will be talking about the FTC and all other relevant franchising matters at the upcoming IFA Advocacy Summit, premier franchise government relations meeting on, you know, in the U.S., on Earth, I would say, from the U.S. to New Zealand or anywhere. That's September 9th to 11th in Washington, D.C. And you can use your phone to click that QR code to register for that. We hope to see everybody in DC. Our thanks again to Dave Cook, Mark Dady, Sarah Davies for all their time and expertise. We hope you found this helpful, everybody, and let's keep in touch on FTC issues as the RFI continues to unfold. But I hope everybody has a great rest of the week and look forward to seeing you next time.
Thank you.
Thank you.